Hey, good morning, everybody in family law. I'm going to put up a quick video on child support, which is chapter 6. I think the chapter is very well organized, but a few students have reached out and says, I like these little summary reviews for whatever reason. I think they're a bit boring, and I know if I had to watch them for the length of time I put them on, I'd feel I was suffering. But nonetheless, I'll put this on just for a brief discussion to maybe enrich what the book provides and what you understand about child support. The first thing I always like to start with when the concept of child support comes up is it is just that. It's child support. It's not support for the mom or for the dad, but psychologically, there's a phenomenon that almost always happens when the payor, the obligor, has to pay the obligee or the payee monies. You don't pay it to the children. You don't put it in the trust fund and have some kind of trustee that's a neutral, making sure that all those funds are spent specifically on the child. The reality is it's got to be paid to one of the other parents. And the expectation is that parent will use that money in the best interests of the child. The courts will not intervene unless it's an abusive situation, meaning that, okay, mom's paying dad $500 a week in child support, and dad's blowing it all at the casino, and little Bobby and Janie aren't being fed, and they're not being housed appropriately, and they're not being clothed appropriately, and they're not being cared for financially under any basically reasonable modicum of review. Outside of that extreme example, the court is not going to interfere because the payee is paying the mother or the father, say, $500 a week, which is a substantial amount of money. You can imagine the person who's paying it, the angst they have coming up with that amount of money net out of their pay. That's a lot of money. You give it to the other side, and that other side, you find out, is doing something. They're going to Florida on vacation. They're going to see some band they want to go see. And they're either working in a very little, they're working part-time at very little income, or they're not working at all. So how are they able to go and do that? Chances are it may be coming out of the child support funds. The court won't get in and micromanage how those funds are expended, because if the kids are being fed and clothed and housed appropriately, the court's simply not going to micromanage, like a trickle down theory in a way, because there is an expectation the money will be spent on living expenses. So if mom or dad has primary custody and they're getting child support from the other parent, that money is expected to go to food, housing, and clothing. That also might go to that parent. It's just not going to get into it. And I hear these stories all the time, and I used to do family law stuff in my law practice. And I hear that goes, oh, look, my ex just got a hairdo, and she's bragging on Facebook that it costs $175. She doesn't even work. I'm paying $1,000 a week. Very high income people. The dad was, and he was paying a lot of money. And I said, there's nothing, and he actually said, I'm going to go to another attorney. And I said, by golly, go ahead. You're going to be spending a lot of money on an attorney. And I guarantee you, your child support obligation is not going to change unless your income has changed and unless mother's income has changed. You can go in for a review, and I guarantee you, if attorney brings up the fact that mom's going out and getting hairdressing done at high expense, or she's buying expensive shoes, or she bought a new car based upon probably the income, it's not income for tax purposes, but the money resources that are gained via child support, court won't touch you with a 10-foot pole. And I've always known this guy. He was a friend, and I got to admit, he burned a little bit of a bridge because he got, I want to go to a lawyer who knows what he's doing, kind of a thing. Yeah, that's great. He did. He hired the lawyer, paid him quite a bit of money, went to court, got shot down. He comes back to me, and we're still friends to this day. But he came back to me somewhat, do some more work on the case as things progress later, because a lot of times with divorces with children, they never really end in some way. There's always new issues coming up about financial things flowing back and forth, or visitation and things like that. And I said, I'll give you some free advice, but I'm not going to work for you anymore. It's like once bitten, twice shy. I get offended very easily. But people really have a hard time digesting the concepts of child support. It's for the child. It's not for the parents. But at the same time, the court doesn't have the time or the resources to micromanage how that money is spent. As long as the children are being well cared for by the primary caretaker, the court's not going to intercede on how those funds are expended. So how do we determine whether someone has to pay child support? Well, let me take the classic example. If one person becomes the primary residential caretaker of the children, called primary custody, they will likely receive child support from the other candidate. If it's less than 70-30, meaning, say I'm the primary caretaker of most of my kids are grown up now, but I have one that's still 15, still lives with me. I'm the primary caretaker of the child. So, and the kid spends more than 70-30, probably 80% of the time with me. So he spends 20% of the time with mom. Should mom pay me child support? Not necessarily. You have to look at the formulas. And I put up on your Blackboard site, if you look at the site there, I think it's right under assignments. I put Massachusetts Child Support Guidelines and Worksheets. It's basically a formula, and you plug in numbers, and it'll tell you whether or not your one party has to pay child support to the other. Chances are I could get a small amount of money from my ex for child support because I have primary, pretty much sole physical custody of my son, and she has visitation. But her income is so low, not her wealth, and we don't usually count that, which is very interesting. We don't say, well, she's got lots of money from inheritance in the bank or whatever she's got her money from. They don't look at that. They look at income. And income isn't simply her having money in the bank. It could be the interest she earns off that money in the bank. It could be interest from an annuity or something like that, or other sources of income from work or the like. But they don't look at simply possessing assets already. So if they look at how much money she makes, and she does work part-time and she has some income, I could probably get a diminished amount of money. But because of the nature of it and the fact that I don't want to create problems, I don't seek child support. But at one time, we did have a child support issue going on back and forth. And at one time, we had what we call joint physical custody. It was 50-50. Very difficult balance. We went over that in the last chapter. Now, what are you doing is 50-50. Now, some people think, well, if it's joint physical custody, there's no child support because both parents are co-parenting. That's not true. What they do is they look at what if I had sole custody, what would I get from her? And they look at her, if she had sole custody, what would she get from me? And then there's a differentiation between the two. So if I make more money than her, I'll probably have to actually pay my former spouse some child support, even though there's equal physical custody. And that's even true in the 70-30. Say I had 70% custody, she has 30% visitation, but it's 30% of the time for types of custodial custody called the shared custodial arrangement. I may still actually have to pay child support if my income is so disparate to hers in the offset, and then you do the numbers 30% versus 70%, she might be due some money, believe it or not. And that shocks people sometimes. But the thing is once it becomes shared custodial, the strict guidelines don't apply anymore. And that's why some people actually fight for shared physical custody, because the rigid guidelines of the child support order of Massachusetts aren't as applicable. There's more flexibility for the court to change it a little bit, because sometimes people are sticker shocked when they come in my office. I don't do family law stuff anymore, but when I did, they'd sit down to me and I'd sit down, nice guy, and talking to him, goes, oh, I love my kids. I spend a lot of time with them. Probably going to spend, 25% of the time, not because he doesn't want to spend time with kids, but he's like a long range truck driver. He's out of the area a lot, but he's going to spend probably 2 weekends a month with them. He talks to them every day on the phone, very close to his kids, spends a lot of time when he has vacation, almost exclusively with his kids. And he says, hey, so mom's going to be primary caretaker. Good mom. She's a great mom. He goes, how much? He goes, we've come to an agreement. Careful on this one. You can agree to divide marital assets all you want, but when it comes to child custody, you can agree provided it doesn't go below the minimum that the guidelines, the formula provides. And so he said he had an agreement with his wife, his ex-wife. He says, there's 4 kids. He says, like in my situation, he says, yeah, I'm going to pay $250 a week. I said, okay, she's in agreement with that. Yep. And he goes, we just need to sign the paper. He goes, well, we don't need to just sign the papers. She's going to have primary physical custody. We have to go through the child support guidelines required by law. He had to pay double that. He had to pay over $500 a week in child support. And he goes, but we have an agreement. And I said, yeah, but the court won't allow, because the money's not to her. The money is for the children, and you're not going to be allowed. The court basically, that's why we have the court, to oversee, to protect children and spouses if they're being kind of taken advantage of, whether knowingly or not knowingly, whether it's bad intent or good intent. This guy was so freaking mad. And on that case, because he was hostile, I remember saying, go and talk to a couple of attorneys. And he came back to us. Every single one of them said the same thing as you did. That's what I'd have to pay. And then he said, so it's kind of sad in a way. He said, I want to fight for joint physical custody, because he didn't want to pay that much money in child support. And I said, but you can't be here all the time. And he couldn't fathom that the money was really going for the kids' benefit. And many people can't. It's very, very difficult to swallow. But child support is for the benefit of the kids. Massachusetts has one of the more liberal, meaning fairly significant awards of child support go from the obligor to the obligee, because we want kids to be taken care of. We don't want kids to suffer. If anybody's going to suffer, it's going to be the parents financially, not the kids. And that's the goal. And believe me, I know the sting of paying a lot of child support at times during my history, and I know other people who have. The payor often feels very much like they're being taken advantage of, and the payee feels like they're not getting enough money at all. Because if you're a stay-at-home parent, luckily, when I got custody of all the kids, it was over 20 years ago. The I had flexibility in my careers that allowed me to be at the kids when they went off on the bus and be home pretty much when they got off the bus most times. And otherwise, it's how can you? It's just a tough road to hoe to be the primary caretaker. And if you're not the primary caretaker, you're spending less time with your kids, but you're probably paying money, and it's a lot more money than people think. And how much? Look at those child. I gave you a take-home little exam thing for fun. I don't care if you get it right. I just want you to try it because over time you get better at it. Most family law attorneys and paralegals have software right in the office. You plug in the numbers and it computes them very accurately. And again, the court will allow the payor, if they want to pay more, all day long. Hey, we want to pay extra child support. I ain't got a problem with that. It's when you try to go under it. Are there exceptions why you can go under it? Yeah, and the book does a nice job talking about some of the exceptions. And I got to talk about all these other things here. Defining income. Okay, so we know about that. Just looks at the income of the custodial parent. It does not, and I wish the book didn't mention it. It does not look at a new partner. So, say for example, my ex-wife remarries and she marries a really wealthy guy. That guy's got absolutely no obligation to support my children financially. So it has no impact at all. People try to bring it up all the time. Court just says, I'm sorry, but the new Mrs. Corman, my new wife, or my ex-wife's new husband, they don't have any role in the factors because they have no obligation to support our children. We know in the big picture, the chances are there's probably going to be some benefit from somebody who has some economic contribution to be made and are willing to do it, but the court can't mandate that. And so therefore the court usually ignored a new partner in the relationship of either mom or dad. One that they do sometimes occasionally is, hey, I want to pay a little less child support because my kids are freaking loaded, right? You can argue that why the kids loaded. Maybe they got a great grandparent created some trust fund for them and they have money available for them for everything from clothes and housing and education. I should be able to pay a little bit less because they have resources to protect them. And the court might consider that. I've never had one in my case, but I know it's in the law. Multiple families. That's a nice term for saying, my buddy's coming over later, my mechanic. He has 4 children from 4 different women. Actually, 2 of the kids one of them just got married. Time flies. But when I met him, he was paying 4 different women child support. The guidelines take into account when you're paying child support for another child. You can't, because if you're paying the full amount as if that's the only child, he would have a negative income as a result of paying it based upon one family. So they count and consider child support obligations flowing to other kids. So the first kid gets a little bit of a reduction, so the second kid gets income, and then when the third and fourth, they all have to be looked at as if they're one unit. There's only so much money to go around. And that makes sense. Extraordinary expenses come up sometimes. Extraordinary expense, maybe I don't have health insurance has changed a lot, but maybe I have a huge deductible and I have to go in for weekly chemo treatments or something like that, and it's life-saving treatment, and I really need a reduction in child support to be able to survive. They might look at that. Sometimes even the custodial arrangements, very rarely will that have an impact. Be careful on this one. Say dad's paying X number of dollars a week in child support, and he's supposed to see his kids every 3 weekends a month. And dad keeps blowing off seeing Junior. It's heartbreaking to Junior. Mom's really upset because she made plans because she'd like to have a free weekend once in a while to do something with her friends. And, she's anticipating being able to have some free time. And little Junior's can't wait to go see dad, and dad just doesn't show up. Can mom say, as a result of that, I want more child support? Generally, no. And vice versa, the same way. Can dad say, hey, I went to pick up my kid last Friday. It was my weekend. I'm supposed to pick him up at 5 in the afternoon on Friday. I'm supposed to really keep him the Sunday night. I went over the house, and her brother who lives there said, they went away for the weekend. No, it's COVID, so no one's going away anywhere, but went away for the weekend. She meant to tell you, but, she just got this last minute chance to take the kids up, skiing up in Bretton Woods, and she's gone for the weekend. Can my client now not pay child support for that week because he got denied his child visitation? No, it's mutually exclusive. They don't look at parental conduct for how they are complying with visitation schedules and custodial schedules as to the obligation of paying financial support. The only one that can determine changing of financial support is the court. Got to be very cautious on that. Sometimes you'll have a guy say, hey, paying $500 a week. I get this really good job. And I just got laid off, and now I make half as much in unemployment. I'm going to start paying half as much in child support. You might be able to do that if the court agrees to it. But even if your ex-spouse agrees to it, it's always a good idea to get that change of order in the court records. Otherwise, you might be held in contempt. But more importantly, the other person might get all that arrearage with interest. Got to be very cautious on that. And it talks about what can happen to the payor if they don't pay. And I know people that have had this happen. They used to jail people for quite a bit for months at a time for failure to pay child support. That's become less in vogue. But what's still popular is losing a driver's license. I know someone that's lost their master's plumber's license as a result of failing to pay child support and basically being in contempt, not having good cause why, or not saying, all right, I'll catch up, I'll do it. These people just say, I'm not paying child support. I haven't been able to see my kid. I'm estranged from my kid. Mom's really put a wedge between me and the kid. I'm not paying child support. You can go to jail for that. So there's contempt proceedings like that. But the driver's license is a real killer. The other is if you work over the table, a traditional job, you can have your tax return seized, and they often are. You can have your bank account seized. I don't do much family law now, and I tried not to do much back in the day, but my people in my office did a lot of it. And you have these clients coming in, they'd be so upset. He goes, geez, my entire bank is frozen. I can't get at it. She did something with DOR, Department of Revenue. They often help in the collection of child support for the payee or the obligee. Very, very powerful tools out there, and they really go after you big time. People are often surprised about that. And the tax return, the one that just came up is that stimulus thing we all have. Not all, but many of us had. If you paid so much in taxes or something like that, I forgot what we got. A certain amount of money if you made so much income or something like that. My same friend, the one that I told you about, with the 4 kids, he's not in contempt right now, but he is in arrears. If you're in arrears on child support, you didn't get that stimulus money, and he didn't get it, and so he's madder than hell. But we want to really put pressure on the payor to pay their money, because it's not, again, for adults, it's for kids. A different eligibility service. And why? Because if you're not getting your child support, who's going to support those kids if there's not a safety net? It's going to be the government. It's going to be taxpayers. So taxpayers want to get their money back, so they often participate in getting a piece of pie. Then they have the percentage of the parent's income. The old rule of thumb, if someone is just guessing right off the top of my head, you got one kid and there's going to be one parent that's a primary caretaker. The non-primary is roughly going to pay a third of their income unless there's a huge offset towards one child. Then every other child, it goes up a little bit more. It doesn't double, because at some point it gets ridiculous. It goes up a little bit more in the percentage. Defining income. That's a big one. A lot of people say, oh, geez, my husband makes $60,000 or $80,000 a year. And I'm having a hard time collecting, and I want to hire you. I don't understand why it's such a hard time. He's got to fill out a financial form. He asks for his tax returns. You show he made this much money. You don't make any money because you're staying home with the kids. It's just kind of I don't know what's going on. And then they say, well, he works as some kind in construction. I guess there's still jobs that exist like that. They get paid under the table, or they pay you one check and they give you cash for another portion of them. She can't prove that he makes $85,000 a year. She can prove that he makes $30,000. I said, well, unless you're willing to go out and prove through, a private investigator or some kind of other evidence, alternatively, the person does have this kind of income, then it's going to be a tough road to hoe for you. And the other thing that comes up, this is a genuine thing that happened to me, not in my divorce, but in my life. I always wanted to be a professor. I don't know if I gave this spiel in this class, but I always wanted to teach at a community college, because I'm a product of community college, and I initially failed and flunked out basically, or quit. And I ended up returning to it because it was the only place that would have me back. And eventually something turned on right, and I had a few good professors, and I fell in love with the I don't know, the whole thing that the community college represents, the little man and woman kind of being able to forge ahead in life if you want to give it a stab. And I really did love the community college system, and I want to go back to it as a teacher. And so I figured, well, you don't come back as a teacher unless you get an education, master's degree or better. And I grew up right near a law school, and my dad, I love politics. You see all the political stuff behind me. And so my father says, go to law school. You're right in the neighborhood. You can almost maybe not walk. You can ride your bicycle to law school, and I'll help you through it. And I love living with my parents. I'm one of the geeks, I guess you call me, a nerd or whatever. I lived in my parents' basement. Probably, if I didn't marry and have kids and stuff, I'd probably still be there today. Although they wouldn't be there because they've died. Oh, my mom's still alive. Terrible gallows humor. I apologize. But so I went to law school, and after law school, I started practicing, and an opportunity came back up to teach. Now, when I was practicing law, I'm not saying I was making tons of money. I was doing pretty well. teaching at the community college paid me less. Let's assume that, let's say mom gets primary custody. I'm a lawyer and I'm making X number of dollars a year. I'm going to pay so much child support. Now, all of a sudden, I decide, like, finally, my dream, my goal in life has been to teach at a community college, and I'm going to work there for half the income. Should I be able to go to court and get a reduction of my child support because I don't have as much money to live on? And the answer generally is, well, you can always try to go to court and get a reduction. But my ex might be able to argue, and I think I don't blame someone for doing it, saying, but there's imputed income, meaning he had the ability to clearly make, I don't know, say it's $100,000 a year, and now he's taking a job for $50,000 a year. The court generally will impute income because it's for the child's best interest to say he was and can and could still make $100,000 a year, but he's opted voluntarily to make 50. We're going to impute like he's making 100. However, if I could prove through evidence that this has always been a lifelong goal of mine to work in that industry and suits me better psychologically, emotionally, and it's just been an aspiration of mine really from since I was 18 or 19 years of age, and the amount of child support I'll pay is enough to keep my kids well clothed and fed and educated and warm in the winter and cool in the summer and all that kind of stuff, the court might well allow it. So that's, I think I put that on that little take-home test thing. I call it take-home. One of those questions about imputing, because sometimes people want to change careers for a much lesser degree. In fact, a case just came down in Massachusetts that the wife, who was the payer, made big money doing something, I don't know, like real big money. She's paying a ton of money in child support. And in the midst of, 4 or 5 years go by, she took a different job paying a whole bunch less. And the husband, the dad said, no, I'm going to sue you for you're not going to get a child support reduction. And the trial court, at the probate level, said, no, you're going to have to pay the higher amount because you had that ability to pay it. The appeals court, or the Supreme Court of Massachusetts, no, you can't force her to work in employment that she really genuinely does. She's not doing it to avoid paying child support. She's still paying a figure that makes the necessary means available for the kids to survive economically. Child support's some nasty stuff. I've actually met somebody that said they were going to quit their job so they wouldn't have to pay so much in child support. Careful, that's where they will do imputed income, especially if they can prove you quit your. But it's just psychologically, they don't think of the money going to the kids. They think of the money going to the ex-wife or the mom or the ex-husband or dad. Not always married. Child support doesn't. You don't have to be married to owe child support as long as you're the parent of the child. Gross income, adjusted income, net income, setting an income base, custody visitation arrangements. New partner, again, does not matter at all. Extraordinary expenses, that does come up sometimes, very rare to argue. You do an offset for the health insurance that pays. So if I'm paying child support and paying for the health insurance of my kids, that's considered a deduction in the formula. All works that out in that worksheet if you take a look at it. Financial disclosure is a big thing in the court in Massachusetts. I got that guy with the 4 kids. He had 4 kids with single women, and he never got married to any of them. Then he got married and was married for about 2 years, and now he's getting a divorce, and because he works on my cars, and we've become friends. We're very different than one another, and but you don't pick your friends; it just sort of happens. So I decided to help him through the divorce. I thought it'd be very easy, but one of the things about a divorce, whether there's kids involved or not, they don't have kids together. You have to fill out financial statements. And financial statements are the lifeblood of how the courts figure out how to divide marital assets and how much money the kids get. And you get a lot of trouble for relying on these things. In fact, in Massachusetts, probably for the past 15 years, when my client signs his financial statement, this is a true and accurate statement of the money I have coming in and the assets I have. Again, the assets don't matter for child support so much as the income. What do you make on a weekly basis? Not only does the litigant, the party in the action, sign it under the pains of penalty, the attorney has to say in good faith that they believe that's true. So if my client said to me, yeah, Jim, I'm making $30,000 a year at this job, but I make another $25,000 a year doing mechanic work under the table. And I said, well, we have to put that down. You say, well, were you such a nerd? I'm like, well, I'm not just a nerd, and I am a nerd. I'm also, I believe, very ethical. And lastly, if the court should find out, we're going to lose everything. Courts just nail people that perjure themselves on those forms. Don't do it. And there's some examples in the book of the 5. I put up the one for Massachusetts. I'm not going to test you in Massachusetts. You should just get familiar how Massachusetts works. Most states have similar formulas. They just might not be as lucrative or as as the same figures might, but there's a methodology that which we get to do it. Many of the times when there's a court judgment on it, it goes through DOR, meaning that, say, we went through DOR, my client, he finds out he's got to pay his ex-girlfriend, $150 a week in child support. If I'm representing the payor, I like it not to go through the Department of Revenue, meaning the Department of Revenue will actually deduct it from your paycheck for you and then send it off to the mom. And vice versa. The mom might be the payor, DOR will take it out of the mom's paycheck, send it over to the dad. The reason why I don't like DOR is sometimes DOR gets the record screwed up, and then they try to hold people in contempt of court because there's some snafu in their system, or they sometimes take out a double withdrawal. And it's a nightmare. I don't like going through DOR. DOR is it's like working with the registry of motor vehicles. Anybody ever had a problem with the registry of motor vehicles? Try to figure out which line to stand in just to figure it out. The same with the DOR. So when my ex and I were working, I'll give her credit and hopefully me credit, both of us decided not to go through DOR because I think in good faith, whatever we figured out what needed to be done, we were going to do the right thing and honor whatever agreement or judgments we come to. I'm not a big fan of that. But if you're the party receiving the funds on the other side, you might want the DOR to collect that money for you. Otherwise, the person's going to do what? Constantly be late, or months go by, and sometimes the DOR won't help you after the fact until they're in arrears by several $1,000s. It can be a long time before the DOR acts, where if the DOR is initially involved right from the get-go, they basically put the screws to the payor if they miss even one payment or late even one, because they're directly withdrawing it from payroll. So it's cut both ways. It cuts both ways, the DOR thing. Credit reporting licenses can be removed. Federal tax offsets, talked about that. Oh, and interstate is interesting. You get a judgment out of Massachusetts and you get court consent to move to Tennessee. The Massachusetts court order is fully enforceable in Tennessee. That's called the comity clause. It sounds like comedy, but it's comity, COMITY. Basically, other states will enforce the judgments of another state as long as it was valid entered into that state. So it's universally enforceable, pretty easy. Contempt, there's civil contempt. Most cases are civil contempt. You go to the probate family court, not anymore because of COVID, everything's being done online, or Zooms is crazy. But when they used to do things in a traditional courtroom, half the day was about contempts, and the contempts were about someone's not giving me the right visitation, or they're not paying child support, and it's a nasty place to be. The only place I think worse than the housing or the family divorce court over contempts over child custody and support is housing court is just a very negative place. I do a lot of criminal law, so that's the scariest place to be. I disagree. I'd rather be in criminal court than family court or the housing court any day of the week. So modification, adjustment of modification, major change. I shouldn't say major. Usually it's got to be a substantial change in circumstances. Usually it's financial. So say my client makes $100,000 a year, mom makes $25,000 a year working part-time, he's paying a significant amount of child support, and he gets laid off. Maybe the industry he works in is affected by COVID. Should he be able to get a modification of child support? Absolutely. In the court looks, but be careful. It doesn't modify it retroactively. So you can't let a year go by and you found a way to scrape together the money and pay it to the mom, and then all of a sudden file it. The modification only can take place from the date of filing with the court. It doesn't go back and do things retroactively. That's a very big word of caution there. Those of you that can be paralegals or attorneys, act on your rights right away, because whatever's been paid is never going to be recouped. Things can't go back retroactive. Very important. Yeah, the review period. I'm saying with that, like, what if my client was making, like, again, $100,000 a year, his ex-spouse is making $25,000 a year, and we find out mom suddenly, because kids are a little older, she has a little bit more, freedom, if you will, to work outside the house for a period of time, and she went on and got a degree or whatever, and now she's making $60,000 a year. Should dad maybe benefit from that as a result of higher income of the custodial parent? Absolutely. And that's why every so often you can just ask for a 3-year, usually it's 3 years in Massachusetts, just a review of the status if you want. Other than that, you have to identify that there's been a substantial change in circuit. You have to know that something's changed. Oh, emancipation is a big change. When does emancipation occur? In Massachusetts, generally speaking, when a child returns to the age of 18, but sometimes the court will put in there, can be up to the age of 23 if they're enrolled full-time in college, or there's special needs of the children. That almost can be a permanent order if there's lack of ability to live independently. But usually is 18, goes into military service or becomes married. I have a 20-year-old. He's not emancipated because he's not in full-time college right now. He's living at home, so he's not emancipated per our agreement. You can always agree on different dates. Our agreement is emancipation at 18 if they are either working full-time or not in college. So my son is not in college, and if you were working full-time, that'd be great. So all of my kids, the other kid's 21, he's finished college, and so has my 24-year-old daughter. They finished college, they're emancipated. And so you put all those things in the agreement. We'll get to settlement agreements later. In most divorces and disputes end with settlement agreements. And in those settlement agreements, you want to spell out in a lot of detail, like who's going to pay for college, what are the parents going to contribute? Because generally the court won't order one parent to help when it comes to the cost of college. And that can be a real controversy because that's above and beyond standard child support obligations. But what is emancipation? Again, going to military service, oftentimes receiving the age of 18, but the court will often inquire, goes, I'll make it 18 if they're not going to college full time. But if they are going to college full time, then up to the age of 23. Why 23? Well, because a lot of students take more than 4 years to complete college, for a 4-year degree. What's interesting about that comes up for disputes a lot is, and let's face it, many of you probably experience this or will, you go to college 1 year, the next year, because of life circumstances, you got to catch up with some money issues or something like that. You take a year off or a semester off. Child support, you've been emancipated now because you're over the age of 18. You're not in college full time, so you go out and work. But now you decide to go back to college and you're living with mom. Should mom be able to resuscitate or revive the child support? Man, what a pain in the butt, and it really is. And we can put all those things in the agreement that, provided that the gap in education. And if you don't, you get those phone calls all the time, and it's more money for the attorneys and more headache for you as a client or for our clients. The other is death of the parent. If the parent dies, their estate doesn't necessarily pay child support anymore on behalf of the children. It can actually go after an estate. I'm not going to get too deep in that. But obviously, if a child dies, the obligation of the parent to pay child support on behalf of a dead child is no longer obviously on the table. Adoption. Now, this is an interesting one. A lot of people think I don't really see my kids at all. Mom has moved away with the kids and they got a stepdad that's a great guy. I hate paying child support. I don't get to see my kids really. Why don't I just voluntarily give up my parental rights to my kids? Can I do that? Yes. But in Massachusetts now, it doesn't terminate necessarily my obligation to pay child support, believe it or not. That stuns a lot of people. Now, obviously, if mom's not looking for any kind of child support, it might not go anywhere. But what if mom says, your former father, he's terminated his parental rights. We want to go after him for some child support. She probably will be successful in the state of Massachusetts if the kids are in need of financial resources. However, what if stepdad, mom remarried, what if stepdad now adopts my children because I've terminated my parental rights? Then under that circumstances, as long as the kids aren't economically suffering, then maybe I'd get out of the obligation because they've been adopted by a third party. Careful though, adoption alone is not enough. We don't want them to be a ward of the state or live indigently. If I have enough money and the kids don't, I may remain legally obligated to financially support kids that are legally no longer mine. Surprises a lot of people. We don't have early emancipation in Massachusetts. Well, there's a theory that you can under certain equitable circumstances, but generally speaking, you can't go to court and say, look, I'm 17, I'm working full time, I'm sick of my parents, I want to be emancipated. There's no mechanism for that generally. Usually it's just called living independently, but you're still legally under the authority of either your parents or the Department of Children and Families. Student. Be careful about child support on this. The payor, say I'm paying a bunch of child support, I can't write that off on my tax return as like a business expense or an expense against income. It's not deductible. And if my wife is receiving child support, it is not income from her. Some people try to mask alimony as child support and vice versa to get a tax advantage one way or the other. The courts look at that very cautiously, and so does the IRS. Because if I was paying my wife alimony, I'd get a tax deduction. So I might say to my wife, hey, let's not fight over child support. Let's not say we owe any child support, but I'll give you $500 a week in alimony. That way I'd get a tax deduction if I was in the higher bracketed income. It might benefit me greatly. And say my wife doesn't work that much, so her obligation to claim it as income might not mean she'd have to pay much out in taxes. It might be a benefit, basically ripping off the government, really, about taxes on half of the way we claim alimony versus child support. Again, child support not deductible for the payor and not includable in income for the payee. I think that's pretty much it. Longer than I wanted to go, but there's another review.